I knew something was wrong the moment I heard the industrial equipment rolling down Maple Grove Lane at 6 in the morning on a Tuesday in September. My name is Aaron Dalton, and I had been living in my house in Henderson, Nevada, for exactly 3 years. It was a modest 3-bedroom ranch-style home that I purchased with the money I saved from working as a civil engineer. The property sat on what I always believed was a generous lot, with plenty of space between my house and the community park that bordered the western edge of my land. Or at least, that is what I thought until that fateful morning when everything changed. I stumbled out of bed, still wearing my old college shirt and pajama pants, and looked out my bedroom window. What I saw made my blood run cold. There were trucks, workers in bright orange vests, and what appeared to be surveying equipment being set up on the grassy area behind my house. The area where I had spent countless weekends mowing, where I had planted a small vegetable garden, and where I had installed a bird feeder just last spring. I threw on some jeans and a hoodie and rushed outside, my bare feet sliding into the sneakers I kept by the back door. The morning air was crisp, and the sun was just starting to peek over the horizon, casting long shadows across my yard. "Hey, what's going on here?" I shouted as I approached the nearest worker, a middle-aged man with a weathered face and a clipboard. He looked up at me with a mixture of surprise and confusion. "Are you with the HOA?" "No, I live here," I said, pointing back at my house. "This is my property." The man scratched his head and looked down at his clipboard. "According to our work order, this is HOA common area. We're here to install a new paving plant staging area. The actual plant will be temporary, but we'll be doing a lot of repaving work throughout the community over the next 6 months. My heart started racing. There must be some mistake. This is my backyard. Before the worker could respond, I heard a voice that would become all too familiar in the coming weeks. "There's no mistake, Mr. Dalton." I turned to see a woman approaching from the direction of the street. She was probably in her late 40s, with perfectly styled blonde hair that didn't move despite the morning breeze, wearing a pantsuit that seemed far too formal for a construction site. She had that particular expression that I would come to know well, a mixture of smugness and barely concealed irritation. "I'm Patricia Winters, the president of the Maple Grove Homeowners Association. Perhaps we haven't met formally, but I assure you this land is designated as common area in our community master plan." I stared at her in disbelief. "Patricia, I've been mowing this grass for 3 years. I have a vegetable garden right over there. This is clearly part of my property." She pulled out a rolled-up document from her leather bag. "According to the community plot map filed with the HOA, your property line ends at the fence post approximately 15 feet from your back door. Everything beyond that is common area, maintained by the association for the benefit of all residents." "But there is no fence," I protested. "Exactly," Patricia said with a tight smile, "which is probably why you've been confused. But I assure you, the boundaries are clearly marked in the official documents. We've decided to use this space for a temporary paving plant because we're doing a major infrastructure upgrade throughout Maple Grove. The roads need resurfacing, and it's more cost-effective to have the plant on site rather than trucking materials in daily." I looked at the workers, who were now beginning to unload more equipment. "You can't just set up an industrial operation without even telling me." "We sent notice to all affected homeowners 3 weeks ago," Patricia said, her tone becoming more clipped. "You should have received a letter in the mail." I hadn't received any letter, but arguing about that seemed pointless at the moment. "I want to see the property survey." My actual property survey, not some HOA map. Patricia's expression tightened further. "Mr. Dalton, I understand this is unexpected, but the HOA has every right to utilize common areas as we see fit for the betterment of the community. If you have concerns, you're welcome to attend our next board meeting on the 15th of next month. Next month? You're setting up a paving plant right now. Yes, we are. Now, if you'll excuse me, I need to ensure the contractors have everything they need. Have a good day, Mr. Dalton. She walked away, leaving me standing there in shock as the workers continued their setup. I stood there for several minutes, watching as they began marking out areas with spray paint and setting up what looked like temporary office trailers. I went back inside and immediately started searching through all my paperwork. I had kept every document from when I purchased the house, organized in a filing cabinet in my home office. I pulled out the folder labeled Property Documents and spread everything across my desk. There it was. My property deed, issued by the Clark County Recorder's Office. I read through the legal description, which included coordinates, measurements, and boundaries. According to this document, my property extended much further than 15 feet from my back door. In fact, it clearly stated that my western boundary was marked by a line approximately 120 feet from the rear of the house, which would include all the area where the workers were now setting up their equipment. I grabbed my phone and took photos of every page of the deed. Then I went outside with my phone and started taking pictures and videos of the workers, the equipment, and the entire area. I wanted documentation of everything. Over the next several days, the situation escalated rapidly. The workers brought in massive equipment including cement mixers, paving machines, storage containers, and a small mountain of gravel and asphalt materials. The noise was unbearable, starting at 6 in the morning and continuing until 6 at night. The smell of hot asphalt and diesel fuel filled the air, making it impossible to enjoy my backyard or even keep my windows open. I tried calling Patricia Winters multiple times, but she never answered, and she never returned my messages. I sent emails to the HOA board at the address listed on their website, but received only an automated response saying my inquiry had been received and would be addressed within 10 business days. I decided to take matters into my own hands and visit the HOA office in person. It was located in a small strip mall on the other side of the community, nestled between a dry cleaner and an insurance office. The door had Maple Grove HOA printed in gold letters on the glass. Inside, I found a small reception area with cheap furniture and faded landscape paintings on the walls. A young woman sitting behind a desk looked up as I entered. "Can I help you?" she asked with a practiced smile. "I need to speak with Patricia Winters. It's urgent." "Do you have an appointment?" "No, but this really cannot wait. The HOA has set up a paving plant on my property, and I have documentation proving that they are trespassing." The receptionist's smile faltered. "Let me see if Mrs. Winters is available." She picked up her phone and spoke quietly into it. After a moment, she hung up and said, "Mrs. Winters can give you 5 minutes. Please have a seat, and she'll be right out." I sat down on one of the uncomfortable chairs and waited. It was more like 15 minutes before Patricia finally emerged from a back office. She looked even more severe than she had at the construction site, wearing another pantsuit, this one in navy blue and carrying a thick folder. "Mr. Dalton, I understand you're upset, but I've already explained the situation to you." I stood up and pulled out my phone, showing her the photos of my property deed. "This is my actual deed from Clark County. According to this legal document, my property extends to where you've set up the paving plant. You're trespassing, and I'm giving you notice to remove everything immediately." Patricia barely glanced at my phone. "Mr. Dalton, when you purchased your home in Maple Grove, You agreed to abide by the HOA covenants, conditions, and restrictions. Those CCRs specifically state that certain areas are designated as common space, regardless of what individual property deeds might suggest. This is standard in planned communities. That doesn't make any sense, I said, my frustration growing. How can the HOA override a legal property deed? It's all explained in the documents you signed at closing. Perhaps you should have read them more carefully. Now, I really do have other matters to attend to. As I mentioned before, you're welcome to bring your concerns to the board meeting next month. Next month isn't good enough. I want this resolved now, today. Patricia's expression hardened. Mr. Dalton, if you continue to be disruptive, I'll have no choice but to consider it harassment. The paving plant is staying exactly where it is until our road project is complete, which will be approximately 6 months. I suggest you learn to live with it. She turned and walked back to her office, the door closing firmly behind her. The receptionist looked at me sympathetically but said nothing. I left the office feeling angry and helpless, but I wasn't about to give up. As a civil engineer, I understood property law, surveys, and legal descriptions better than most people. I knew I was right, but I needed professional help to prove it. That afternoon, I called 3 different real estate attorneys in Henderson. The first 2 couldn't see me for several weeks, but the third, a man named Robert Chen, agreed to meet with me the next morning. Robert's office was in a modern building in downtown Henderson, with floor-to-ceiling windows overlooking the city. He was younger than I expected, probably in his mid-30s, with sharp eyes and an attentive manner. I laid out all my documents on his conference table. My property deed, the closing documents from when I purchased the house, photos of the current situation, and printouts of my email exchanges with the HOA. Robert studied everything carefully, occasionally making notes on a legal pad. After about 20 minutes, he looked up at me. "This is interesting," he said. "Your deed is very clear. The legal description gives you ownership of that land, no question about it. The question is whether the HOA CCRs can supersede your deed." "Can they?" I asked. "Generally speaking, no. CCRs are binding contracts, but they cannot override property ownership rights established by a recorded deed. However, there are some nuances here. Let me do some research into Nevada law and the specific language in your CCRs. In the meantime, I recommend you do not interfere with the construction, even though you believe it's on your property." "Why not? Shouldn't I be protecting my property rights?" "Because if this goes to court, and it probably will, you don't want to be accused of obstructing legitimate business operations or causing damage to equipment. Let them continue their work. Document everything, but don't interfere. If we can prove they're on your property, they'll have to remove everything at their own expense, and you may be entitled to damages for the disruption." I didn't like the idea of just watching as they continued to use my land, but I trusted Robert's judgment. "Okay, so what's the next step?" "I'll research the law and prepare a formal letter to the HOA, putting them on notice that they're trespassing and giving them an opportunity to relocate their operation. If they refuse, which I suspect they will based on your description of this Patricia woman, we'll file a lawsuit for trespassing and injunctive relief." "How long will all this take?" Robert grimaced. "Court cases move slowly." "We're looking at several months, possibly longer if they decide to fight it. They said the paving plant will be there for 6 months. Then there's a chance they'll finish their project before the court case concludes. But that doesn't mean they won't be liable for damages and the costs of your legal fees if we win." Over the next 2 weeks, Robert worked on researching the case while I continued to document everything happening on my property. The paving plant was now fully operational, with dump trucks coming and going throughout the day, workers operating noisy machinery, and the constant smell of hot asphalt. My neighbors started complaining too. The family directly to my right, the Johnsons, came over one evening to commiserate. "We can't even sit in our backyard anymore," Mrs. Johnson said. "The noise and smell are unbearable. Did they really not give you any warning?" "Patricia claims they sent a letter, but I never received it," I told them. "We didn't get anything either," Mr. Johnson added. "This is ridiculous. We're paying HOA fees for this." Word spread quickly through the neighborhood, and soon I was receiving phone calls and visits from other residents who were equally upset. A few of them mentioned that they had tried to fight Patricia and the HOA board on other issues in the past and had always lost. "She's untouchable," one neighbor, an older man named Frank, told me. "Been HOA president for 8 years now. Runs it like her personal kingdom. Last year, she tried to fine me $500 because my fence was 6 inches too tall, according to some obscure rule nobody ever heard of. I had to cut down the whole thing and rebuild it." These stories only strengthened my resolve. Patricia Winters had apparently been bullying residents for years, using the HOA as her personal power base. It was time someone stood up to her. Robert finished his research and sent a formal letter to the HOA, outlining my property rights and demanding that they cease operations on my land immediately. The letter was detailed and professional, citing specific Nevada statutes and case law. 3 days later, I received a response, but not from Patricia. Instead, it was from a law firm called Morrison and Associates, representing the Maple Grove HOA. The letter was dismissive and condescending, essentially restating Patricia's original position that the land was common area and that I had no standing to object. "This is actually good news," Robert told me when I forwarded him the letter. "It means they're taking us seriously enough to hire attorneys, but they're not backing down. That gives us grounds to file suit." Robert prepared a comprehensive lawsuit against the Maple Grove HOA, Patricia Winters personally, and the paving company that had set up the plant. The complaint sought an injunction to remove the paving plant, damages for the disruption and loss of use of my property, and attorney's fees. We filed the lawsuit in Clark County District Court on October 15th. I paid Robert a $5,000 retainer, which hurt my savings but felt necessary. This wasn't just about the money or even the property anymore. It was about principle. The HOA's response to the lawsuit came 3 weeks later, and it was even more aggressive than I expected. They not only denied all my claims, but filed a counterclaim against me for harassment, claiming that I had been threatening their contractors and interfering with legitimate HOA business. They were seeking $5,000 in damages, plus their attorney's fees. "This is a classic intimidation tactic," Robert explained. "They're trying to scare you into dropping the case. Don't worry, their counterclaim is baseless and we can easily defend against it." But I was worried. The legal fees were mounting, and the stress of the situation was affecting every aspect of my life. I was having trouble sleeping, my work performance was suffering, and I felt a constant knot of anxiety in my stomach. The paving operation continued throughout October and into November. They worked 6 days a week, taking Sundays off, which was the only day I had any peace and quiet. The area behind my house had been transformed into an industrial site with temporary buildings, mountains of materials, and constant activity. I continued documenting everything. I kept a daily log of the noise levels, took photographs and videos regularly, and saved every piece of correspondence with the HOA. Robert assured me this documentation would be valuable in court. The court scheduled a preliminary hearing for mid-December. This would be our first chance to argue our case before a judge. Robert prepared extensively, creating exhibits, organizing evidence, and preparing his arguments. The night before the hearing, I couldn't sleep at all. I kept going over everything in my mind, worrying about what might happen, wondering if I had made the right decision to pursue this fight. The courthouse was a modern building in downtown Las Vegas, a 45-minute drive from Henderson. I arrived early, wearing the only suit I owned, feeling nervous and out of place. Robert met me outside the courtroom, looking calm and professional. "Remember, this is just a preliminary hearing," he told me. "We're asking for a temporary injunction to stop the operations while the case proceeds. We need to convince the judge that we have a reasonable likelihood of success on the merits and that you're suffering irreparable harm." The courtroom was smaller than I expected, with wood paneling and fluorescent lights. The judge, a woman named Judge Sandra Martinez, entered promptly at 9 o'clock and everyone stood. "Please be seated," she said. "We're here today for the matter of Dalton versus Maple Grove Homeowners Association. I've reviewed the pleadings. Mr. Chen, you're representing the plaintiff." "Yes, Your Honor." Robert stood. "We're seeking a preliminary injunction to halt the trespassing operation currently taking place on my client's property." "And Miss Morrison, you're representing the HOA." A severe-looking woman in an expensive suit stood up. This was Catherine Morrison, the lead attorney from the firm representing the HOA. "Yes, Your Honor. The HOA respectfully maintains that there is no trespassing occurring as the land in question is designated common area. Let's hear your arguments, Mr. Chen." Robert approached the podium and began presenting our case. He explained the situation clearly and concisely, showing the judge copies of my deed and pointing out the specific legal description that established my ownership of the disputed land. "Your Honor, the deed is unambiguous. My client owns this property. The HOA has no right to use it for industrial purposes, or any purposes for that matter, without his permission. The disruption to his life has been severe. He cannot use his backyard, cannot open his windows, and is subjected to noise and pollution 6 days a week, 12 hours a day." Catherine Morrison stood to respond. "Your Honor, when Mr. Dalton purchased his property, he became bound by the HOA's CCRs, which clearly designate certain areas as common space. This is standard practice in planned communities throughout Nevada. The HOA is acting within its rights to use common areas for the benefit of all residents. The road improvement project will benefit everyone, including Mr. Dalton." Judge Martinez looked at the documents before her. "Miss Morrison, I'm looking at the property deed and it seems quite clear. How do you reconcile the deed's legal description with the HOA's claim that this is common area?" "Your Honor, the CCRs were filed and recorded prior to the individual property deeds being issued. They establish a framework that governs the entire community. Individual deeds must be read in conjunction with the CCRs. You have case law supporting that position." Catherine cited several cases, which Robert immediately countered with other cases supporting our position. The legal arguments went back and forth for over an hour, with both sides presenting their interpretations of Nevada property law. Finally, Judge Martinez held up her hand. "I've heard enough for today. This is a complex issue that requires careful consideration. I'm not prepared to issue a preliminary injunction at this time, but I'm also not dismissing the plaintiff's case. I'm going to order an independent survey of the property to be conducted by a court-appointed surveyor. Once we have that survey, we'll reconvene and I'll make my determination. In the meantime, the paving plant may continue operations, but the HOA is hereby ordered to keep meticulous records of all activity, equipment, and materials on the disputed property. It wasn't the victory I had hoped for, but it wasn't a complete loss either. Robert seemed satisfied as we left the courtroom. "The judge is taking this seriously," he told me. "The fact that she's ordering an independent survey is a good sign. She recognizes that there's a legitimate question about property ownership here." The court-appointed surveyor, a professional named David Torres, conducted his survey over the course of 3 days in early January. He used GPS equipment, studied the original plat maps, and carefully measured every aspect of my property and the surrounding area. I watched him work, hoping that his findings would confirm what I already knew. David was professional and thorough, never discussing his findings or opinions while he worked. 2 weeks later, his report was submitted to the court. Robert got a copy and called me immediately. "Aaron, this is excellent news. The survey confirms that the disputed area is definitely within your property boundaries. David's report is very detailed and leaves no room for ambiguity. You own that land, period." I felt a wave of relief wash over me. Finally, validation. So what happens now? We go back to court. With this survey in hand, I'm confident the judge will grant the injunction and order the HOA to remove the paving plant. But things didn't move as quickly as I hoped. The HOA's attorneys filed a motion challenging the survey, claiming it was flawed and requesting that a second survey be conducted. Judge Martinez denied that motion, finding that David Torres was a qualified professional and his methodology was sound. Then the HOA filed another motion, this time arguing that even if the land was technically within my property boundaries, I had acquiesced to the HOA's use of it by not objecting sooner, and therefore had waived my rights. Robert called this argument desperate and ridiculous, but it still required a written response and more time. Meanwhile, the paving plant continued operating. January turned into February, then March. The HOA had now been using my property for 6 months, just as Patricia had originally said the project would last. I had spent nearly $15,000 in legal fees at this point, and my life had been in turmoil for half a year. Several times, I considered just giving up, letting them finish their project and moving on with my life. But every time I saw Patricia Winters driving through the neighborhood in her luxury SUV, that smug expression on her face, I remembered why I was fighting. Finally, in late March, Judge Martinez scheduled a hearing for summary judgment. This would be the decisive moment where she would rule on the core legal question: did I own the property or not? The hearing was scheduled for April 2nd. Robert filed a comprehensive brief supporting our motion for summary judgment, complete with the survey, expert opinions, and extensive case law. The HOA filed an equally lengthy brief in opposition. The week before the hearing, something unexpected happened. I received a phone call from a number I didn't recognize. "Mr. Dalton, this is Brenda Nash. I'm on the HOA board serving as treasurer." I was immediately suspicious. "What can I do for you, Mrs. Nash? I wanted to speak with you confidentially." "What Patricia has done to you is wrong, and several of us on the board know it. She pushed this paving plant location through without a proper vote, and she never sent you the notice she claims she sent. I've been looking through our records, and there's no evidence that any notice was mailed to you." This was interesting. "Why are you telling me this?" "Because I'm tired of Patricia running this HOA like a dictatorship. She's been doing things like this for years, and it's not right. I wanted you to know that you have support, even if it's not public support. And I wanted to tell you something else. The paving project is almost complete. They're scheduled to finish up and remove all the equipment by the end of next week. That's convenient timing, right before the court hearing. Exactly. Patricia thinks if the equipment is gone, you'll drop the lawsuit. She's been bragging about how smart she's been, letting you waste money on legal fees while the project proceeds on schedule. My anger flared, but I forced myself to stay calm. Thank you for telling me this, Mrs. Nash. I appreciate your honesty. Just promise me one thing. When you win this case, and I believe you will, please don't stop there. Patricia needs to be held accountable for everything she's done. After I hung up, I immediately called Robert and told him about the conversation. That's very helpful information, he said. It confirms what we suspected about the lack of proper notice, and the fact that they're planning to remove the equipment before the hearing doesn't change anything. They still trespassed for 6 months, and you're still entitled to damages. True to Brenda Nash's information, the paving plant began dismantling operations the following week. Watching the equipment being loaded onto trucks and hauled away should have felt like a victory, but instead it felt hollow. They had used my property for 6 months without permission, disrupted my life, and now they were just going to walk away as if nothing had happened. By the time the hearing date arrived, my backyard was empty again, though the grass was dead and the ground was compacted from all the heavy equipment. My vegetable garden was destroyed, and the area where I had installed the bird feeder was now just a patch of dirt and gravel. The courtroom was more crowded this time. Robert had told me that summary judgment hearings sometimes drew spectators if they involved interesting legal questions. I recognized several of my neighbors in the gallery, including the Johnsons and Frank. I also saw Patricia Winters sitting in the front row behind the defense table, wearing a black suit and looking confident. Judge Martinez entered, and the hearing began. This time, the arguments were more technical and focused. Robert presented our case methodically, walking the judge through every piece of evidence. The deed, the survey, the photographs documenting the trespass, and my financial losses. Catherine Morrison argued that the case should go to trial because there were disputed questions of fact, including whether I had given implied consent to the HOA's use of the land, and whether the CCRs created an easement that allowed the HOA access to the property. Judge Martinez listened carefully to both sides, asking pointed questions and taking notes. After nearly 2 hours of arguments, she announced that she was ready to rule. "I've given this case considerable thought," she began. "On the surface, it appears straightforward. Mr. Dalton has a deed showing ownership of the property in question. The court-appointed survey confirms that the area where the HOA placed their paving plant is within Mr. Dalton's property boundaries. Property ownership is one of the most fundamental rights we have, and it cannot be overridden simply because it might be inconvenient or because a homeowners association prefers a different arrangement." I felt my heart racing. This sounded promising. The HOA argues that their CCRs supersede the deed, but I've reviewed those CCRs extensively, and I find nothing that establishes an easement or right of use over Mr. Dalton's specific property. The CCRs discuss common areas in general terms, but they do not specifically identify Mr. Dalton's property as common area, nor could they, since his deed predates his membership in the HOA. Catherine Morrison stood. "Your Honor, if I may, the CCRs were actually recorded before Mr. Dalton's individual deed was issued." "That may be true, Miss Morrison, but the CCRs do not specifically encumber Mr. Dalton's property. They provide a general framework for the community, but they cannot override a specific legal property description recorded with the county. If the HOA wanted to use Mr. Dalton's property as common area, they needed to either purchase it from him or negotiate an easement. They did neither. Judge Martinez paused and looked directly at Patricia Winters in the gallery before continuing. Furthermore, the evidence shows that the HOA proceeded without proper notice to Mr. Dalton, and even after he objected and provided proof of his ownership, they continued their operations for 6 additional months. This demonstrates a willful disregard for Mr. Dalton's property rights. Patricia's confident expression was starting to fade. Therefore, I am granting summary judgment in favor of the plaintiff on the issue of trespass. The HOA did trespass on Mr. Dalton's property, and they are liable for damages. We will need a separate hearing to determine the amount of those damages, but I want to be clear. Mr. Dalton is entitled to compensation for the fair market rental value of the property for the 6 months it was occupied, compensation for the damage to his property, and his reasonable attorney's fees. I felt a surge of triumph. Robert reached over and shook my hand, but Judge Martinez wasn't finished. I'm also troubled by the HOA's conduct throughout this litigation. Their counterclaim for harassment was without merit and appears to have been filed solely to intimidate Mr. Dalton and increase his legal costs. I'm dismissing that counterclaim with prejudice and sanctioning the HOA $5,000 for filing a frivolous claim. Catherine Morrison looked stunned. Patricia Winters had gone pale. Finally, Judge Martinez said, I'm referring this matter to the Nevada Real Estate Division for investigation. HOAs are regulated entities in this state, and the conduct I've seen here suggests potential violations of Nevada's HOA regulations, including failure to provide proper notice, misuse of HOA funds, and abuse of authority. The hearing concluded, and as I stood to leave, several of my neighbors came up to congratulate me. Frank pumped my hand enthusiastically. You did it. You actually beat her. Patricia Winters left the courtroom quickly, avoiding eye contact with everyone. Catherine Morrison stayed behind to speak with Robert about scheduling the damages hearing. Over the next few weeks, I worked with Robert to calculate my damages. We determined that the fair market rental value for the property, based on commercial rates for similar industrial staging areas, was approximately $15,000. The cost to restore my property, including new sod, replacing my garden, and repairing the damage caused by heavy equipment, was another $8,000, and my attorney's fees had reached $22,000. The damages hearing was scheduled for May 15th. This would be our opportunity to present evidence of my losses and ask the judge to award full compensation. Before that hearing could take place, however, something unexpected happened. Robert received a call from Catherine Morrison proposing a settlement. The HOA wants to settle. I asked when Robert told me. Why? Probably because they know they're going to lose the damages hearing, and they want to avoid the additional publicity and legal fees. Also, the Nevada Real Estate Division has apparently started their investigation, and I think the board is getting nervous. What are they offering? $50,000, all inclusive. That would cover your damages and attorney's fees plus some additional compensation. In exchange, you would agree to drop any further claims and keep the settlement confidential. I thought about it. $50,000 was more than my actual damages and fees combined. It was tempting, but something bothered me. The confidentiality clause. That means I couldn't tell anyone what happened, right? Correct. It's a standard provision in settlement agreements. So Patricia and the HOA board would get away with what they did, and nobody would know about it. Well, the real estate division investigation will continue regardless. But yes, Essentially, you wouldn't be able to discuss the case publicly. I thought about Brenda Nash's phone call, and all my neighbors who had shared stories about Patricia's abuse of power over the years. I thought about how Patricia had tried to intimidate me, how she had ignored clear evidence that she was wrong, and how she had cost me months of stress and disruption. "No," I said. "I'm not taking the settlement. I want the full damages hearing on the record. I want everyone to know what happened." Robert smiled. "I was hoping you'd say that. Let's finish this properly." The damages hearing took place as scheduled. Robert presented our evidence methodically, including expert testimony about rental values, receipts for the property restoration work, and detailed accounting of all legal fees. The HOA's attorneys tried to argue that our damage claims were inflated, but they had little evidence to support their position. After a full day of testimony, Judge Martinez took the matter under advisement and said she would issue a written ruling within 2 weeks. True to her word, the ruling came exactly 14 days later. Judge Martinez awarded me the full amount of my claimed damages: $15,000 for rental value, $8,000 for property restoration, and $22,000 for attorney's fees, plus the $5,000 sanction she had previously imposed. The total judgment was $50,000. But more importantly, her written opinion was scathing in its criticism of the HOA and Patricia Winters specifically. She wrote that the HOA had acted with willful disregard for clearly established property rights, and that their conduct demonstrated a pattern of abuse of authority that has no place in the management of a homeowners association. The opinion was a matter of public record, and it didn't take long for word to spread through the community. Several residents reached out to me, sharing their own stories of problems with Patricia and asking if I would be willing to speak at the next HOA meeting. That meeting took place in early June, held in the community center. I arrived to find it packed with residents, far more than typically attended these meetings. Patricia was at the head table with the other board members, looking considerably less confident than usual. When the meeting opened for homeowner comments, I stood up. "I want to thank Judge Martinez for her thorough and fair handling of my case against the HOA. The court's ruling made clear that the HOA violated my property rights, and I hope this serves as a wake-up call that the board needs to operate within the law and treat homeowners with respect." Several people applauded. Then Frank stood up. "I move that we hold a special election to recall Patricia Winters as HOA president and as a board member." The applause was much louder this time. One of the other board members, a man named George, seconded the motion. Patricia tried to maintain order, citing various procedural rules about why the motion couldn't be heard, but the crowd wasn't having it. After 30 minutes of heated debate, the board reluctantly agreed to schedule a recall election for the following month. That recall election was held on July 10th, and the turnout was unprecedented. Over 80% of eligible homeowners voted, and the result was overwhelming. Patricia Winters was removed from the board with 73% of residents voting in favor of the recall. A new board was elected, including Brenda Nash as president. One of their first acts was to conduct a full audit of the HOA's finances, which revealed that Patricia had been using HOA funds for personal expenses, including paying herself an unauthorized salary and using HOA credit cards for personal purchases. The total amount of misappropriated funds was approximately $35,000. The new board referred the matter to the Henderson Police Department. In late August, Patricia Winters was arrested and charged with embezzlement and theft. I watched the local news that evening and saw her being led out of her house in handcuffs, looking nothing like the confident, smug woman who had dismissed my property rights 9 months earlier. The criminal case moved through the system, and in November, Patricia pleaded guilty to felony embezzlement. She was sentenced to 2 years in prison, with eligibility for parole after 1 year, and ordered to pay full restitution to the HOA. As for me, the HOA paid the $50,000 judgment in full by September. I used part of that money to fully restore my backyard, planting new grass, rebuilding my vegetable garden, and installing a new bird feeder. The rest went into my savings, helping to rebuild what I had spent on legal fees. The Nevada Real Estate Division completed their investigation and issued a report finding multiple violations by the former HOA board, resulting in substantial fines and requiring the new board to undergo training on proper HOA management. On a cool October evening, almost exactly 1 year after this whole ordeal began, I was sitting in my backyard, which was now green and peaceful once again. The Johnsons came over with some beers, and we sat around my new patio table, enjoying the quiet evening. "You know," Mr. Johnson said, "you could have just accepted that first settlement offer and walked away with the money. Why did you push it all the way?" I thought about that question. Because it wasn't really about the money, it was about the principle. Patricia thought she could do whatever she wanted, that her position as HOA president made her untouchable. Someone needed to stand up to her, and I guess it ended up being me. "Well, the whole community is grateful," Mrs. Johnson added. "The new board is actually listening to residents and following the rules. It's like we have a completely different HOA now." Frank, who had also joined us, raised his beer. To Aaron Dalton, the man who took on the HOA and won, we all clinked our bottles together, and I smiled. It had been a long, difficult fight, but in the end, justice had prevailed. The following week, I received a letter from Robert Chen. Inside was his final bill, marked paid in full, along with a handwritten note. "Thanks for letting me work on such an interesting case. You were a great client because you never gave up, even when things looked difficult. That's what it takes to win cases like this." I kept that note, along with a copy of Judge Martinez's final opinion, in a frame on my office wall. They serve as a reminder that standing up for what's right is worth it, even when it's hard, even when it costs you time and money, even when powerful people try to intimidate you into backing down. The Maple Grove community continued to thrive under its new leadership. Brenda Nash proved to be an excellent HOA president, transparent and fair in her dealings with all residents. The roads that Patricia had claimed needed repaving turned out to be in decent condition, requiring only minor repairs, not the major overhaul she had insisted was necessary. Several residents suspected that Patricia had inflated the scope of the project to benefit the paving company, possibly in exchange for kickbacks. But that was never proven. As winter approached and the holidays drew near, I found myself reflecting on everything that had happened. I had bought this house 3 years ago hoping for a quiet place to live, and instead, I had ended up in a legal battle that lasted most of a year and fundamentally changed the community. But I wouldn't change any of it. Sometimes the right thing to do is also the hard thing to do, and this had definitely been both. The important thing was that I hadn't backed down when someone tried to take advantage of me. I had stood my ground, trusted in the legal system, and ultimately prevailed. On Christmas Eve, I hosted a small gathering at my house for some of my neighbors. We stood in my backyard, the same backyard that had been an industrial staging area just months before, now peaceful and covered in a light dusting of snow that occasionally fell in Henderson during winter. "You know what the best part is," Frank said, looking around. "This, right here, We're standing on your property on land that you fought for and won. That means something." He was right. It did mean something. It meant that property rights still matter, that bullies don't always win, and that sometimes one person standing up for what's right can make a difference for an entire community. As my neighbors headed home that evening, I stood alone in my backyard for a few minutes, looking up at the stars. My phone buzzed with a text message. It was from Brenda Nash. "Merry Christmas, Aaron. Thank you again for everything you did. You saved this community." I smiled and typed back, "Merry Christmas, Brenda. We all did it together." And that was the truth. Yes, I had been the one to file the lawsuit and see it through, but I couldn't have done it without Robert Chen's legal expertise, without Judge Martinez's fair and thorough consideration of the case, without Brenda Nash's inside information and support, and without my neighbors who stood by me and eventually voted to change the leadership. The final chapter of this story came in early January, when I received notice that Patricia Winters was being sued in civil court by the HOA for the full amount of her embezzlement, plus damages. The new board was determined to recover every penny she had stolen, and they were also going after her for the costs associated with the lawsuit she had forced the HOA to fight against me. I didn't attend any of those proceedings. I had closed that chapter of my life and moved on. Patricia was no longer my concern. She was the legal system's problem now, and I trusted that justice would continue to be served. By February, my life had returned to a comfortable routine. I was performing well at work again, sleeping through the night and actually enjoying my property. I had even started dating someone I met at a community event, a teacher named Sarah who thought my story about taking on the HOA was both crazy and admirable. "You're either very brave or very stubborn," she told me on our third date. "Probably a little of both," I admitted. "Well, I'm glad you did it. This neighborhood needed someone like you." 1 year after the paving plant had first appeared on my property, I organized a small anniversary gathering. It was partly a celebration of the victory, but mostly just an excuse to get together with the neighbors who had become genuine friends through this experience. We set up tables in my backyard, and people brought food and drinks. Someone made a joke about setting up a small paving plant as a lawn ornament, which got a big laugh. The new HOA board members attended, and there was a genuine sense of community that I hadn't felt before all of this happened. As the sun set and people started heading home, Frank pulled me aside. "You know, I've been thinking about writing up this whole story and submitting it to the local paper. People should know what happened here, how one person stood up to a corrupt HOA president and actually won. It might inspire others who are dealing with similar situations." "You have my permission," I said. "In fact, I'll help you write it if you want. The only thing I insisted on during settlement negotiations was that there be no confidentiality clause. I wanted this story to be public record." Frank's article ran in the Henderson Tribune a few weeks later, under the headline "Local Resident Defeats HOA in Property Rights Battle." It was well written and thorough, explaining not just what happened, but also the broader implications about property rights and HOA governance. The article generated significant interest, and I received several calls from people in other communities facing similar issues with their HOAs. I did my best to offer advice, always emphasizing the importance of documentation, knowing your rights, and not being afraid to stand up to bullies, even when they have institutional power behind them. Robert Chen called me after the article ran. "You're becoming quite the local celebrity," he joked. "Maybe you should start a consulting business helping people fight HOA disputes." "I think I'll stick to civil engineering," I replied, But if anyone needs a good real estate attorney, I know exactly who to recommend. As spring arrived and the anniversary of my victory approached, I found myself thinking about what lessons I had learned from the entire experience. The most important one was simple: documentation is everything. If I hadn't kept my property deed, if I hadn't taken daily photos and videos, if I hadn't maintained detailed records of every interaction, my case would have been much harder to prove. The second lesson was about persistence. There were so many moments when I could have given up, when continuing the fight seemed too expensive or too difficult or too time-consuming. But each time I was tempted to quit, I reminded myself why I was fighting in the first place. It wasn't just about my property. It was about standing up to abuse of power. The third lesson was about community. I had lived in Maple Grove for 3 years before this happened, but I barely knew my neighbors. The adversity of dealing with Patricia and the HOA brought us together, created bonds that might not have formed otherwise. Now, I had genuine friendships with people I had previously only waved to in passing. By the time summer rolled around again, life in Maple Grove had settled into a new normal. The HOA functioned smoothly under competent leadership. Residents felt heard and respected, and the community had learned valuable lessons about governance and accountability. Patricia Winters served her time in prison and was released after 13 months. I heard through the neighborhood grapevine that she had moved out of state, starting over somewhere far from the scene of her crimes. I didn't wish her ill, but I was glad she was no longer in a position to abuse power or take advantage of people. The spot where the paving plant had stood was now the nicest part of my backyard. I had put extra effort into that area, planting flowers, installing decorative stones, and creating a small meditation garden. It seemed fitting to turn the site of conflict into a place of peace. On the 2-year anniversary of when this all began, I hosted another gathering in my backyard. It had become an annual tradition, a way to remember what we had been through and celebrate how far we had come. More neighbors attended this year than last, and the mood was festive and light. Brenda Nash gave a short speech, thanking me again for having the courage to stand up to Patricia and ultimately triggering the changes that transformed the HOA. "Aaron showed us that one person really can make a difference," she said. "And he inspired all of us to pay more attention, to get involved, and to demand better from our leadership." After everyone left that evening, I sat alone in my backyard, in the meditation garden that now occupied the former paving plant site. The air was cool and still, and the stars were bright overhead. I thought about everything that had happened, all the stress and uncertainty and anger, but also all the growth and friendship and justice that had come from it. My phone buzzed with a text from Sarah, who I was now seriously dating. "How did the party go?" "Perfect," I typed back. "Peaceful, just how it should be." And that was the truth. After 2 years of upheaval and conflict and legal battles, my life was finally peaceful. My property was mine, clearly and legally and without question. My community was well governed and harmonious. And I had learned that standing up for yourself, even when it's difficult and expensive and scary, is always worth it in the end. The story of my battle with the Maple Grove HOA became something of a local legend in Henderson. Robert Chen mentioned it in marketing materials for his law practice. The new HOA board used it as a cautionary tale in their training materials about proper governance. And I occasionally got recognized at local restaurants or stores by people who had read about the case. But mostly, I just went back to being a regular guy living in a regular house in a regular neighborhood. Except now my backyard was truly mine, undisputedly and legally mine. paid for not just with money but with principle and persistence, and the courage to stand up for what was right. And every time I looked out my window at that spot where the paving plant once stood, now transformed into a beautiful garden, I was reminded that sometimes the biggest victories come from refusing to back down, even when everything seems stacked against you. Justice may move slowly, but it does move, and truth and right do eventually prevail. That was my story, the story of how I took on my HOA, waited until they finished their illegal operation on my property, and then pulled out the deed in court to prove they were wrong all along. It was a long road, full of frustration and expense and stress, but in the end, it was absolutely worth it.